Thank you. So good afternoon once again. As I mentioned, I'm a lawyer, and I've been working on issues related to freedom of expression, access to information, but also platform regulation in different parts of the world in this. In the recent times, I've worked a lot with UNESCO, providing legal support, but also training judges, regulators, journalists, lawmakers, etc. In this area. And I wanted to take this opportunity just to frame the discussion with a few thoughts that I think that are important to take into account within the context of this discussion, from the perspective of international human rights, which is, of course, a relevant framework, a necessary framework of this discussion, since, of course, Bangladesh has ratified the most important human rights treaties, so in principle they should also be inspiring the legislation of Bangladesh. The first thing that we encounter here, the first element of this discussion, of course, has to do with cybercrime, cyber security laws. The existence of legislation in these areas is, say, something that I would say it's even not only necessary but also desirable in order to, of course, protect the interactions, communications using digital channels. Of course, the risks of fraud, impersonation, phishing, let's say, stealing data, guaranteeing the security of financial transactions is a must. There are, at the international level already, several treaties dedicated to these matters. The Council of Europe, for example, many years ago adopted the Budapest Convention on Cybercrime, that was then ratified by many countries beyond the Council of Europe, so it had become a reference at the global level. But also we have nowadays a recently adopted UN Convention on Cybercrime, the Hanoi Convention, that my understanding is that Bangladesh is considering also ratifying this convention. However, we need to understand that there's a difference between tackling cybercrime in relation to crimes that are directly connected to the use of the digital space. And here we are talking again about fraud, phishing, interception of communications, stealing of data, affecting financial transactions, and the use of the term cyber security to kind of persecute activities that take place in the space online, but do not necessarily need this online space to take place. No? And here we're talking about speech. Speech is something different, and something that has been criticized by international organizations, or has been recommended by international organizations to states, is that states shouldn't use cybercrime legislation to create new forms of illegal speech. That is a very important principle. It's not that hate speech or defamation shouldn't be illegal. They should be illegal, but you don't need to create a different, new, separate category of hate speech or defamation just to apply it to the online world. Because usually when legislation does such a thing, does it in order to introduce a definition that is much broader, far less precise, that opens the door to control speech online in ways that can be even more intense than the way speech is protected offline. So in many cases, I mean, the key issue is that what is legal is something that basically should apply both online and offline. Harassment is harassment, doesn't matter where it happens, how it happens. Hate speech should be hate speech, doesn't matter how it happens, where it happens. Try to, again, use the concept of cyber security to introduce vague provisions to criminalize very vaguely defined attitudes or behaviors, such as spreading rumors, spreading non-confirmed information, stirring hate, things like that, that can be interpreted in a very open manner, would contradict international standards. That's the first idea. The second idea is that, again, the cyberspace should be regulated, but it is very important not only to have precise, clear regulation targeting cyber-dependent activities, but also this legislation should be implemented by bodies that have a sufficient level of A, expertise, and B, independence. Since very important fundamental rights are involved in the use of the cyberspace, the intervention of authorities in this area should be based first in knowledge, good knowledge and expertise of what we are talking about, but also a sufficient degree of independence. And this is, in terms of comparative best practice, where we have, it's true, there are cybersecurity, cybercrimes institutions in many countries, but these institutions are not appointed. They don't have government officials as members, and they are subject to very strict judicial scrutiny. And also, I think that it is very important that these laws in the area of cybersecurity, cybercrime, contain very specific provisions safeguarding the right to freedom of expression, and particularly safeguarding the rights of journalists, for example, the right to protect their communications and to protect the confidentiality of sources. It's true that in some cases, I mean, you can intercept, law enforcement could intercept certain communications when it comes to preventing a crime, but these provisions should also be accompanied by specific safeguards to avoid that these cannot be used to spy, to surveil journalists. For example, Europe has recently, the European Union has recently adopted a law called the European Media Freedom Act that contains specific safeguards when it comes to surveillance provisions, the use of surveillance techniques affecting journalists. So that's the first thing that I think that some general remarks on how we need to understand the need to protect cybersecurity and cybercrime. It is something that we need to do, but it's something that we need to do within certain limits. The second thing that was mentioned also by you, I think it's a very important discussion, and we need to have a proper understanding of the difference between illegal and harmful content, particularly in the online world. Of course, what is illegal online, what is illegal offline should also be illegal online. We already said that. No more than that, no less than that. But it's true that in some cases there are behaviors that are not illegal, they shouldn't be prosecuted, they shouldn't be persecuted, but they might be harmful within the context of the society. For example, in most liberal democracies, disinformation is not illegal, basically because defining disinformation in objective legal terms is impossible and would lead to the creation of a ministry of truth, and we don't want that. So disinformation is not illegal, but at the same time is considered to be a harmful behavior that, let's say, needs to be tackled through other policy instruments. And also here, the role of online platforms is particularly important. Online platforms have a margin to define what is harmful, what is not acceptable in the context of the respective platform. So the role of laws and policies should be to incentivize, to introduce duties of care for platforms to adopt certain responsibilities when it comes to avoiding the dissemination not only of illegal content, but also harmful content. But this should be clearly differentiated within the law. One thing is to have a piece of illegal content on a platform, and here, of course, we need to understand that there will be a judge, an independent body that will address the platform and ask the platform to tackle that matter. And the other thing is talking about harmful content. Here, it's not about specific pieces of content. Here, for example, in Europe, we have the Digital Services Act that says that platforms should be transparent in the way they handle harmful content, that platforms need to adopt certain mitigation measures when it comes to harmful content. Platforms need to be transparent when it comes to the algorithms that they use to promote content, but states cannot indicate specifically what should be harmful or not in references to specific pieces of content. This is a differentiation that I think that is important to take into account. The fact that harmful content is not illegal does not mean that the law cannot introduce certain duties of care, particularly for platforms, regarding the way they handle these kind of problematic content. That was the second reflection that I wanted to express here. When it comes to this second matter, I need to particularly stress the fact that UNESCO has a series of guidelines regarding the governance of online platforms. And these guidelines precisely define this kind of responsibilities, that platforms need to deal with harmful content, they need to deal with it in a transparent manner, and when dealing with it, they are even also subject to fundamental rights requirements, to the respect of fundamental rights. I think that this is where the discussion around platform regulation should take place. And there's a third area, because I think this is also, and I don't want to take much of the time, I understand and I acknowledge that these are very complex topics, and each of the topics that I mentioned would require, I don't know, a 2-day seminar, but the third one would be the issue of data protection. My understanding is that you already have 2 acts and an ordinance regarding these matters. I think that data protection compared to online platforms is something that is, from a comparative perspective, even from a human rights perspective, something that is more consolidated. We already have certain standards, certain solutions that have been there for decades. And for example, they are crystallized in Europe in the GDPR, the data protection, the regulation, so that the model is relatively clear. But of course, when I look into the proposals, into the ordinances and the laws that there are in these countries, from the perspective of an international lawyer, what I see is that there are some things that they need to be further discussed and considered. The first thing is that in data protection systems in many parts of the world, there is independent oversight. There's a body, a data protection agency that is in charge of making sure that the law is properly enforced. But this data protection agency is in no way a government body. Members are not appointed by the government, they are appointed by the parliament with a special majority following a certain procedure, and there's no way they can receive instructions from the government. I think that here, this is a discussion, this is something that is still missing in this country, the creation of an independent data protection agency. Secondly, when it comes to the use of regulatory power, the bodies that have the power in the field of data protection, when you read the law, you see that they have huge power to have access to all sorts of data in their activities of monitoring and inspection, etc., without practically no safeguards. That can also be problematic. In many cases, these measures should not only be adopted by an independent body, but in many cases, also depending on the type of data collection, that authorities may be doing. You even need the authorization of a judge. And this is something that is I don't see in the legal framework here, and this is something that we can also discuss. Another thing is that we need to be aware of the fact that there are limitations in terms of jurisdiction. We can only cover the treatment of data, the processing of data that takes place in the country. Trying to expand the scope of data protection rules beyond the limits of the country is something that is probably not realistic, technically complex, and affects the very idea of jurisdiction. It's fair to say that, for example, France tried to do something similar a few years ago when it comes to Google, and there was a French court that said, and even the European court said, you can only have jurisdiction over your territory, you cannot go beyond that, for example. Another issue is penalties. I believe that this is an area where the infraction of the law should not be criminalized. I don't think that criminal law is the appropriate instrument here. If you want to foster an economy based on data, you cannot use the criminal law as a threat in cases of, let's say, not fulfilling the legal obligations. Also, the laws are very vague when it comes to these matters. And there's also the issue of the protection of children when it comes to access to data. Here, I think that establishing limits when it comes to the capacity of minors to kind of have access to their data by certain actors is commendable. But we also need to understand that if we have these kind of provisions in a legal system, you need to have age verification mechanisms. Age verification mechanisms that are efficient, that are effective, and that properly protect the right to privacy. So let's be careful sometimes with these kind of provisions when introduced in laws, because then you need to have proper verification mechanisms, proper ways to make sure that these laws are properly implemented. And in countries where you still have a significant digital divide, the absence or the fact that some people may not have these age verification mechanisms may imply that they may not have access to certain digital services simply because they cannot prove their age. So that is something in terms of the implication of the enforcement of certain provisions that needs to be taken into account. So these are, some reflections regarding the new legal landscape that we see that is opening up. But I would like to finish also by emphasizing that beyond digital, beyond the new areas, still in Bangladesh there are plenty of laws affecting traditional media, affecting freedom of expression in general, that probably need to be updated in order to be fully aligned with international human rights standards. So let's not forget about that. Also, traditional media, when it comes to traditional media, non-digital, analog, also there are elements, access to information, safety of journalists. There are provisions that are still lacking, things that still need to be done, probably laws that need to be repealed, and we shouldn't be neglecting that. The digital world is important, but not everything is digital, and we shouldn't forget that. Thank you very much for all your interventions. I think you have raised many important topics, I believe. I have a few comments. The first one is on platform liability, because it's quite tempting to say platforms are now liable for all the content that they host. But if we adopt that position, we are basically delegating the regulatory power in private hands. Because if you're telling platforms from now on, you are responsible to define what is legal, what is illegal, not to define, but to assess what is legal, what is illegal, what is acceptable, what is not acceptable. The platform may play that role, but then they will do it in a completely opaque manner, And it will be the platform, not the judge, not the regulator. It will be the platform. It's a privatization of regulatory power, which is extremely dangerous for freedom of expression. So that's the first thing. The second thing, I understand your complaints, and I hear them a lot in many countries. Platforms don't listen, platforms don't respond, etc. But there's a fundamental element here that creates this situation. I'm not saying that platforms, of course, because of their business interests, because, of course, they want to avoid issues, they want to avoid to enter any, complicated situation. But also, there's something that really helps platforms to adopt this position, which is legal uncertainty. In markets where there's legal certainty, platforms are forced to do things. Because there's a clear law that says, okay, if you get a request from a judge, this is what you need to do. If you operate in this market, you need to have a legal representation in this market. If you receive a complaint from a civil society organization, you need to handle this complaint in this way, and you have the legal obligation to provide a response to that civil society organization. If you have all these things in a law, then platforms will have no excuse. But if you have a legal system that is broad, open for interpretation, where we really don't know what is legal, what is illegal, depends on how you interpret it, the platforms will say, look, you're telling me that this is illegal, but I don't know. I read your law, could be legal, could be illegal, I don't know exactly how to proceed. And exactly what is the consequence. So, if you look into more regulated markets, and I'm not talking only about Europe or the UK, I'm talking about Australia, even Indonesia, Brazil, even India to a certain extent, where the behavior of platforms is clearly framed, then of course, the possibilities to push them to do things change in a completely radical manner. Just today, the Irish regulator, which is the regulator of Meta, because Meta is in Ireland, has opened an infringement procedure against Meta because Meta is not properly allowing users in Europe to choose the kind of algorithmic moderation that they want. That's a legal obligation. There was an investigation by the Irish regulator. They said, you are not doing this job properly. I open an infringement procedure. Meta will even have to pay a fine. Well, that's a completely different landscape. No? So, it's true that platforms may not be tempted to engage, but partially that's because of the lack of a legal framework that clearly defines the duties of care, the responsibilities of platforms. I think that this is very important. Then also another reflection about the spread of bad content. And this is a reflection that I always do in many countries. In many cases, platforms reflect the reality. So if you have a polarized society, social media will be polarized. You have a society with, let's say, very harsh people expressing themselves in a very harsh, strong manner in the streets, in the universities, in other areas. The same will happen online. So, sometimes we use platform regulation or platform prohibitions to solve problems that are deeper in our societies that need to be addressed through social cohesion, constructive policies, education, literacy, etc. No? So in many cases what is said is that you cannot completely get rid of bad content online, but you need to live in a society where bad content has a lesser impact because people are more educated, because there's alternative good content that is also available, because you also have access to media that are professional, that are ethical, and therefore you can compare, etc., etc. You have a good state broadcaster, you have fact-checking, etc., etc. No? So it's not about, you cannot police the networks and now we are going to eliminate everything that is bad. But we need to do as much as possible so that good things are there as well, and people understand how to handle the bad things. No, it has been proven that disinformation has a very low effect in plural societies and liberal democratic societies, because of course you have access to reliable sources of information, and then you will not believe what you see, because someone says something and you don't believe that. Just to put an example from a different country, I remember that it's a simple one, but I think I like it. And it's a personal experience. I remember talking to a judge in a certain country. The judge was saying, we need to tackle this information because people say that my salary is $10,000 a month. And then I asked the judge, but is your salary public? And he said, no. And then, well, if your salary was public, then even if someone says that you make $10,000 a month, it would be obvious that it is a lie because your salary is transparent. If you are not transparent, you're opening the door to misinformation, disinformation, etc., etc. No, so that's another. I think that, as you say, I mean, when it comes to bad content online, particularly hate speech, what is important is to tackle this kind of content that can be associated to harm in the real world. Because otherwise, the only thing, if you prosecute something that is, say, not tasteful, that is offensive, but it's just that, then the only thing that you are doing is amplifying it and victimizing those who spread this type of content. Just focus on really harmful behavior, true incitement to hostility, to violence, not other things. No, I think that is the other thing. And of course, something that has been mentioned here, we don't have a solution for that, but we need to be aware of the importance of understanding the difference between having laws and enforcing the laws. Without good enforcement, you can have the best law that you can imagine, but without a proper understanding from judges, from law enforcement, from all those involved, then it will not work. If you live in a country where the law enforcement will ignore the law and do something else, well, then the problem is not only about having a good law, it's about something else. No? So I think that this reflection, having good regulators, having good law enforcement, having good lawyers, at the end of the day, good judges, is also as important as having good laws. No? Thank you.